But also others have been beginning, or other countries also began to explore the development of new digital rights in specific domains. For instance, mapping selected gaps where there is a need for algorithmic transparency and accountability for decisions made by artificial intelligence. While other countries have prioritized protecting rights online in the same way that they are protecting offline. This calls for constitutional recognitions that the rights that are provided to you or are guaranteed to you should also be recognized online. All right? So what are some of the key considerations that we think the Namibian Data Protection Bill should consider regarding digital rights in particular? So number one, we've been asking, or we think that, for instance, the current bill need to recognize and dedicate a sort of section or provisions that recognizes the rights of users. But the bill should include a standalone clause that recognizes the rights of data subjects, right to transparency, rights to access, right to be informed, and rights to rectification, rights to restricting processing, data portability, a right to object, very important, right not to be subject to automated individual decision making, and including profiling amongst others. I just saw when Mr. Muhapi was presenting the sort of sections of the bill, and the copy that I have are totally different. So previously there has been some sort of mentioning in part 4, section 43, where there's exceptions that makes mentions of the rights, but the rights need to be stipulated because this is a people's bill, right? And it should focus on people, right? But also the right to be forgotten. I'll be happy to, I'll share with you, I think in my next slide, just a small case study on the right to be forgotten in Namibia. So we believe that the bill should have a clause that provides for the right to oblivion, that is the right to delete information and records of the past in the cyberspace, and clearly spell out the data retention period. But also specific consideration regarding whistleblowing, right? As a right, bill should have a clause that guarantees the protection of whistleblower in terms of handling investigation, right? That also goes to work with the revision of the Whistleblower Protection Act, number 10 of 2017. So while the right to be forgotten, I think I've just mentioned this. Does anybody knows these people? Yes, right? The lady here knows somebody. Can we get an engagement? Director of somebody? Yes, if you want to get a mic, right? Could you just tell us about them?
What did you recognize in the picture? That's the question. You didn't marry, what is it?
Please raise your hand if you know anything about what you see on.
Who want to give it a try?
I think the lady here has said something. Please, I'm not putting you on the spot. Just say something, right?
I remember the young gentleman in the blue. There was a video online going viral about him. I kind of just forgot about what, but yeah, he stays in the north, that side of Chile, if I'm not mistaken.
Then you have.
Thank you. Yes. So that's a bit of context on the photo on the, is that far right or left? All right, far right. Right, this gentleman is a young, vulnerable boy who has been coming online without obviously his consent, right? A lot of us see many of these vulnerable Namibians. We take photos of them because they're saying something funny, and we post them online for likes and for anything else, right? Most of the time we buy them alcohol so that they can be as entertaining as possible for our likes on social media, just amongst others. Right? That's their data. That's the gentleman's data. This boy, I want to believe, used to be under 18. And this was a Google search. This Google search should have increased by today about this young man. He has not consented for his data, for his information to be online, right? So he cannot even ask, perhaps when he becomes as literate as possible, to get all of that information to be taken off, right? He has a right to be forgotten. He has a right not to be onto the internet, right? Because he has not consented to be on the internet. Right here is Auntie Vivi. I'm sure many of us has also gotten to know Auntie Vivi. So the lady that died, I think, over 9 years ago in Namibia was covered obviously by mainstream media, but also covered by a lot of us under the same context as Irimari over there. She has died. Her information is still onto the internet. I think if you just do a Google search or Facebook search, you still find all of her videos being vulgar and entertaining people for a small beer or whatever that we pay these people to get online. This lady and her family has the right to be forgotten and not to be onto the internet, right? And whether she stays onto the internet, that decision should be made by her family, maybe want to preserve her memories or whatever. But she has never had a Facebook account or Google account or put on information online, right? So the right to be forgotten, and the reason why we are asking that the bill, for instance, should recognize that as a digital right, right? And then obviously there's also some key gender considerations, right? We have asked previously that the bill should prioritize a specific section in the protection of women online, in accordance with CEDAW, but also Article 18 of the African Commission on Human and People's Rights. That there was a need to include provisions of criminalization of online violence against women and girls, and this should to Section 14 of the should work with Section 14 of the data of the draft cybercrime bill of 2019. I'm not too sure what the versions of the current version of the bill that we have. What we have also asked is that as part of the digital rights, that there's a need to introduce nuances to the rectification process that includes specific provisions for victims, particularly of online violence. Currently, the process of rectifying harms, as was outlined in Section 9, lacks specific measure for restitution that can be taken by victims in the case of non-consensual image sharing or revenge pornography, and generally in the commercial loss of data. All right. There was also a need to expand Section 53. I think this is the version that I had of yesterday, regarding trans-border flow of personal data. This will have to do with addressing obligations to victims in the case of transfer of data by perpetrators, and this should also align with Section 13, 15, 17 of the Cybercrime Bill of 2019. Other general considerations were just that there's a need to include time under which the security breach of users should be notified, that there's a need to strike a balance between the protection of national security and the exercises of rights of ordinary individuals, and finally to specify sensitive data